When it comes to legal work for your startup, timing is everything. If you bring in a lawyer too early or you go to the wrong firm, a big portion of your capital can end up going straight to legal fees instead of into your business. On the other hand, if you wait too long and try to handle things yourself, you end up paying 10 times more to fix everything when you try to raise your next round or sell your company. As a startup lawyer myself, I've worked with hundreds of companies and I've seen both scenarios. So my goal for this video is for you to walk away knowing exactly when you need a lawyer at each stage of your startup and when you can get away without one. So let's get into it. Incorporation stage. Let's start at the very beginning, which is when you're forming your entity. This is the stage where founders try to save money by using services like Stripe Atlas or LegalZoom. And if your situation is simple, those services will do the job for incorporation. And when I say simple, I mean a few specific things. Let's say you're a solo founder or you have one co-founder. You haven't brought on any founding engineers yet. There's no complicated equity structure and you're incorporating as a Delaware C Corp from day one. If that's you, Stripe Atlas will get you a clean incorporation and you can move on with building your company. Now, where DIY services stop working is when there's any real complexity. If you have multiple co-founders and you've already brought on founding engineers, you've got to figure out how to split equity between co-founders and what vesting schedules will look like, which is basically the timeline that determines when each founder actually earns their equity. Then you also need to figure out how founder stock gets issued at the right time for tax purposes and who owns what IP that's already been created. Then you also need to figure out how to issue equity to your founding engineers as well. And none of that is something a DIY tool will handle for you. Also, the cost of getting this wrong at the start compounds quickly. Founders often think for one reason or another, like maybe they talk to an accountant or another founder and that founder or accountant says, start as an LLC because you can just fix it later. And also founders won't get the benefit of the time for QSBS that they were an LLC. And in every one of those cases, a lawyer upfront would have cost 5 to 10 times less than paying one to fix it later. Fundraising stage. Now, once you start raising money, the legal side gets a lot more serious. The moment you take money from investors, there are federal laws that control how you're allowed to raise, what you need to file, and who you can take money from. The consequences of getting it wrong happen years later when you're trying to raise again or sell the company. So let's start with the angel round, because that's where the lawyer question comes up the most. A lot of the time, angels are friends or family, so a founder might think no lawyer is needed. But the moment someone signs a SAFE or a convertible note, securities laws now apply. And if you're not familiar, a SAFE stands for Simple Agreement for Future Equity, and it's a contract where the investor gives you money now and then gets equity later when you do a priced round. A convertible note is similar, except it functions as a loan or debt that converts into equity instead. Anyway, one of those securities laws says you have 15 days from the signed SAFE to file what's called a Form D with the SEC. If you don't file this form, the investor can come back and take their money, you can get fined, and you might even get precluded from ever raising again. I've seen instances where founders get into disputes with their investors and the investors use it as a leverage point to sue the founder, because it's an easy way for the investor to attack founders when there's a dispute between investors and founders, for the investor to say, hey, you were supposed to file this form and you didn't. So the fix for this costs way more than just hiring a lawyer would have in the first place. And once you go beyond the angel round, there's no debate. The moment you're talking to institutional investors, seed funds, or VCs, you need a lawyer, because term sheets are where all the important stuff gets decided. And if you sign a term sheet without understanding what you're agreeing to, you're locked in. Things like liquidation preferences, board seats, voting rights, and anti-dilution clauses can all strip you of control over your company if they're structured the wrong way. By the way, If you want a lawyer who specializes in startups to go through your specific legal setup and tell you exactly what to fix, click the first link in the description to book a free consultation with me. On that call, we'll figure out if anything is missing or set up wrong, and I'll show you exactly what needs to happen next. Now let's keep going. Scaling stage. At the scaling stage, the legal work expands across a lot more areas. Because once you have paying customers and you're hiring employees, the number of things you need legal help with multiplies quickly. Now, most of it doesn't feel urgent in the moment, which is exactly why it gets put off or skipped. But bad contracts, written, or even worse, that are missing during this phase are what make buyers walk away from acquisitions 3 or 4 years down the road. I've seen deals blow up because of missing IP assignments where the seller never got IP assignments from key employees or co-founders that have since left the company. And the company also never properly secured that employee's departure via a separation agreement. And the key employee or co-founder popped up during the acquisition and demanded to be compensated for their contributions that were never properly assigned or released to the company via a separation agreement. So with that said, let's start with customer contracts. Once you have real customers, you need proper master service agreements or terms of service, SaaS subscription agreements, and data processing agreements. The 4 provisions that matter most in any customer contract are termination, warranty, indemnification, and limitation of liability. If any of these aren't done right, you're carrying unknown risk on every single customer relationship. And the damage from contracts that aren't done right usually shows up years later when you try to sell the company. Because when you get to due diligence in the sale process, the buyer's lawyers go through every customer contract line by line. So if your contracts have unlimited liability, short termination windows, or unreasonable uptime guarantees, buyers see that as risk they're inheriting. I had one deal that almost blew up because the seller's contracts didn't allow for assignment of the customer contracts upon acquisition, which means that an acquisition could effectively terminate all the customer contracts. The buyer decided to lower the acquisition price significantly to make up for the lack of assignment provisions in the customer contracts. Now, the other important part during scaling is your IP and employee setup. Every employee, contractor, and founder needs a signed IP assignment agreement, which is the document that says that anything they create for the company belongs to the company. If someone contributed to your product and didn't sign one, they can claim ownership of that IP later. I've seen acquisitions completely fall apart because one early engineer never signed an IP assignment and came forward right before closing asking for a payout. Lastly, the exit stage is where the lawyer you pick matters more than any other point. And what's at stake here is pretty obvious, because this is usually the biggest financial transaction of your career. But the mistake that costs founders millions at exit happens before any of the paperwork even starts, and it comes down to the type of lawyer founders bring in. The common move at this stage is to just use the same corporate lawyer you've been working with, but if that lawyer is a generalist or hasn't actually done M&A transactions before, you're gonna leave money on the table or just lose the deal entirely. That's because M&A is a completely different specialty than startup, incorporation, or contract work. A generalist can technically draft the documents, but they won't know what to push back on, what to flag as a risk, or how to structure the deal to protect you. One of the last deals I worked on, we had a first-time acquirer use a lawyer that clearly drafted their purchase agreement using ChatGPT, and it was missing a lot. I represented the seller in the deal, and we were really happy when we saw the ChatGPT agreement because it was really favorable for my client who was the seller. It was missing a lot of the typical protection language for the acquirer, and the lawyer for the acquirer clearly didn't really know what they were doing, otherwise there's no way they would have used this agreement agreement. Now, the deal started in September and was supposed to close in November, but then the acquirer decided to get a second opinion from an actual M&A lawyer, and the deal ended up closing at the end of February because the M&A lawyer rewrote the entire purchase agreement to make sure it was more in line with standard M&A agreements. This is a great example of the difference between using an M&A lawyer and other kinds of lawyers. Then, the other mistake is hiring a big law firm. If a firm is used to handling billion-dollar transactions, they'll staff your deal the same way they staff their biggest ones. So you've got partners billing $1,000 to $2,000 an hour, multiple associates billing underneath them, and a final bill that can be six figures even on a small deal. So what you need at exit is a boutique M&A lawyer, someone who's closed dozens of these transactions, knows what's standard and which terms are worth fighting for and which aren't. And because they're right size to your deal, your transaction gets the attention it deserves. Now, if you're a founder at any stage of your startup and you want to figure out exactly what legal work you need right now without overpaying or leaving yourself exposed, click the first link in the description to book a free consultation with me. We'll go through where your company is today, identify what needs to be handled based on the stage you're at, and make a plan that fits your actual situation. Again, click the first link below, and if you want to learn the 6 common legal mistakes startups make, then check out this video next.